What is a judicial convention anyway? Can everyone, first of all, see my screen? Can everyone see that? Okay, excellent, excellent. All right, so let's jump right in. First of all, this is an event that is hosted by the Four Freedoms Democratic Club. I know we have folks who RSVP'd who are members of other clubs around the county. That's wonderful. If you want to introduce yourself in the chat, you are more than welcome to. But yeah, this is an official Four Freedoms Democratic Club event, and we are excited that you are all here. So these are some of the topics that we are going to cover this evening. What is the state Supreme Court? Who can be a Supreme Court justice? How are Supreme Court justices elected? And what is a judicial convention? And we're gonna, I think, spend the most time on that, but I thought it was important that we understand a little bit about the state Supreme Court and what it is and who runs to be a justice. So let's jump right in. About the state Supreme Court. So under the New York State Constitution, the state Supreme Court has unlimited jurisdiction in both civil and criminal matters, with exceptions, some monetary claims against the state of New York itself, but by and large, any civil case above $25,000 and any felony criminal cases are heard in the Supreme Court here in New York City. I want to make that clear. In some other counties, criminal cases are heard in county courts, but that's not the case here. We hear felony cases in Supreme Court. Something that's really important to understand is that the state Supreme Court is a bit of a misnomer because in most places, the Supreme Court is the highest court in the land. That is actually not the case here in New York State. There actually are two courts above it, the Appellate Division, as well as the Court of Appeals. So there are two places you can go after state Supreme Court. And I want to share with you now a pretty cool little graphic that I got off of the sources at the bottom there, moderncourts.org, which just visually shows you the structure of the courts here in New York State. So you can see state Supreme Court down there on the bottom left. But as I said, above that, you have the Appellate Division. And then at the very top is the Court of Appeals. So that is actually the highest court in the land. So when we talk about state Supreme Court, it is still a very important court, but unlike a lot of other places, it is not the highest court in New York State. And I think that that's important to understand. So who can be a Supreme Court justice? Legally, a Supreme Court justice must be admitted to practice as an attorney in New York for a minimum of 10 years. Legally, that actually is the only requirement. There is no requirement that a Supreme Court justice even serve as a judge in a lower court. Here in Manhattan, it's fairly unheard of to have any justices of the Supreme Court who were not previously judges, civil court, usually in civil court. I know there are some judges in housing court, but primarily judges move from civil court up to the state Supreme Court. In other boroughs, this happens in Brooklyn and Queens. Sometimes they do elevate somebody directly to Supreme Court, but that is, I've never seen it happen in Manhattan in the 10 years that I've been involved. Other folks may remember such instances, but it is extremely rare. They are elected to 14-year terms. And a Supreme Court justice may serve until December 31st of the year in which they reach age 70. And I put a little asterisk there because technically Supreme Court justices can apply for what they call recertification, which essentially allows them to continue serving for 2 more years, and they can do that 3 times. So really, a Supreme Court justice could serve until the age of 76 if they so choose. But technically and constitutionally, the age limit for judges is 70 in the state of New York. One important thing to know is that we have a lot of what are called acting Supreme Court justices. So it's kind of complicated, but essentially we only are given a certain number of Supreme Court justices depending on population. There's a formula involved. Obviously, Manhattan has a very big caseload, and we just don't have enough Supreme Court justices to handle them all. So the chief administrator has the power to appoint certain civil court judges to the role of acting Supreme Court justice. They preside over cases in Supreme Court. They get one clerk instead of two, I believe. That's one of the main differences between an acting Supreme Court justice versus an elected Supreme Court justice. And if they want to elevate to the appellate division, you have to be an elected Supreme Court justice. So those are some of the main differences. But for all intents and purposes, many of the justices who are serving right now on the state Supreme Court are what we call acting Supreme Court justices. So how are Supreme Court justices elected? Well, they are elected in the November general election, just like most other elected officials, all other elected officials. So on your ballot this November, you will see justices for the Supreme Court on there. You will likely only see Democrats. Republicans do not generally run people for those positions, not in New York County. The main difference is, unlike other general elections, there is no primary to determine the Democratic nominee. Since 1921, New York has selected its nominees for state trial court justices by party convention. And these conventions are made up of elected judicial delegates. So that sort of brings us to, I think, why most of us are here. Many folks here are serving either as a judicial delegate or an alternate delegate, or have heard the term and are interested in the process. This is why it is. We don't have primaries for Supreme Court justices. It is all decided via these conventions that take place once a year when there are vacancies. And that is how the process plays out. So that is primarily what we are going to be talking about this evening. And I want to give folks a little background because some people find that to be kind of a strange system. I agree. It's a little bit unorthodox. And I want to talk about a Supreme Court case called the New York State Board of Elections v. Lopez Torres. And I don't know how many of you know too much about this case, but I'll give you just a little bit of background. Judge Margarita Lopez Torres was a Brooklyn civil court judge, by all accounts, a very able judge, but she got on the wrong side of the Brooklyn Democratic Party machine because she apparently refused to hire party loyalists to work in her court, which was sort of, part of the unspoken rule in Brooklyn Democratic Party politics is, as a judge, that's what you did. So the party, which still holds a tremendous amount of control over the convention process and the delegates, refused to support her for Supreme Court. So she sued. She sued the State Board of Elections. She claimed that the judicial convention process deprived voters and their candidates of their rights to gain access to the ballot and to associate in their party's primaries. And actually, two lower courts agreed with her. The District Court for the Eastern District of New York and the Second Circuit ruled in her favor. But in 2008, the US Supreme Court ruled against her. And so a lot of folks, when you ask them about this, will tell you that the New York system was upheld at the Supreme Court, and that is absolutely true. But I do enjoy sharing this quote, which you can see here at the bottom, and I'll read it. In a concurring opinion, joined by Justice David Souter, Justice John Stevens said the ruling should not be misread as endorsement of the electoral system under review. And quoting Justice Thurgood Marshall added, the Constitution does not prohibit legislatures from enacting stupid laws. So the Supreme Court said that it was a constitutional system. They didn't necessarily say that it was a good system, but it is the system we have. It has been upheld at the US Supreme Court. And so this is why we have a judicial convention. This is why we do what we do. We try to elect the best possible judges given the system that we currently have. So what is a judicial convention? I have here a fun picture from our 2019 Judicial Convention before COVID-19 changed everything. So following the Democratic primary, the county party holds a convention to select its nominees for Supreme Court. So we just had a primary on June 22nd, and we will be having a judicial convention on August 5th, next Thursday. At this convention, candidates have their names placed into nomination, and the delegates then vote to decide who the nominees will be. These nominees then appear on the general ballot, the general election ballot in November. And so those are the folks that you're going to see on your ballot in November, are the people that this convention nominates next Thursday. And there are currently 2 vacancies on the state Supreme Court. So they will be nominating 2 nominees for Supreme Court. So a lot of folks ask how the number of judicial delegates is determined. Every assembly district has a different number. And I debated adding this slide. It's math heavy, so if math isn't really your thing, feel free to just, I don't know, zone out for a little bit. But I did want to share it with you because there is actually a formula for it. It was set forth in the state Democratic Party rules. So the rules say that we get 1 delegate and 1 alternate from each assembly district, plus an additional delegate and alternate for every 2,500 votes, or fraction of 2,500 votes, cast on the Democratic line in such an assembly district for the party candidate for governor at the last preceding general state election. It is a mouthful. But to explain it, as you can see here, in 2018, which was the last time we had a gubernatorial election, Andrew Cuomo received 37,226 votes on the Democratic line in the 76th Assembly District. So what does that mean? Well, as the state party rules say, we get 1 delegate automatically. It's like filling out your name on the SATs, you get automatic points. But then you look at how many votes the governor got. So he got 37,226. We divide that by 2,500. We get 14.8. So we get another 14 delegates plus 1 more delegate for that 0.8 that's sitting there. And so when you add them all up, that's 16 delegates. And that's how many delegates and alternates the 76th Assembly District has. And so that you don't have to do the math, here is the list for all of the county, or for all of the assembly districts in New York County. As you can see, 67th, which is Upper West Side, has 19, which is the most. But if you add them all up, there are currently 190 elected judicial delegates in New York County. That's a lot. You know, that can change. When I was first getting involved, I believe the 76th had 11 delegates. Then it went down to 7 because there was very low turnout in 2014. And then in 2018, we had incredibly high turnout. And so that is how we got to the number that we have today. So there are a whole lot of delegates. And if you are a candidate running for Supreme Court, ultimately you want to have 96 delegates in your corner to make sure that you have a majority. And so hopefully you will be one of the nominees. I'm just looking at the chat. I don't see any questions and I don't see any hands raised. So I'm going to just go ahead and continue. And in a couple of minutes, we're going to talk much more in depth about the process. And I'm going to bring in a couple of folks who are on the Zoom who have really been a part of this judicial process over the years. So we'll get a little bit of information and you can get a little break from hearing me talk. But I do want to go over who can seek nomination to the Supreme Court. One of the questions that came in with the RSVPs for this event had to do with how notice is given of who can run for judicial, for state Supreme Court. So according to New York County Democratic Party rules, in order to be nominated, so in order for the party to nominate you, a candidate must have been approved by an independent screening panel either this year, or you can have been approved by 2 of the last 4 panels. So if you were approved by 2 previous panels, essentially it grandfathers you in, so you don't have to go into a panel every single year. The screening panels were established to review applicants for election to Supreme Court. They are comprised of appointees from a number of legal and non-legal organizations, as well as community groups. And I know we actually have someone on here. There you are, Matt. Matt Lombardi is a board member of Four Freedoms. He has also served on several of these screening panels. Matt, correct me if I'm wrong, not for Supreme Court, but for civil court. Is that right? Correct. Gotcha. Okay. But very, very, very similar. I'm also checking to see if we have Frank on the call. He serves on the County Judiciary Committee. So I was hoping to give him an opportunity to give us a little more information. But Matt, in the meantime, I would love for you to just talk a little bit about these independent screening panels, the process, both from the perspective of a panelist, someone who has served in sort of, screening folks for civil court. So I'll just hand it over to you. Would love to just kind of get your take on the independent screening process, what you think of it, what it is, and how it helps us to determine who the best candidates for judge are.
Sure. The independent screening panels are a mechanism to try to vet the legal qualifications of candidates. And they're composed of nominees from different various civic groups, community groups, such as the New York State Trial Lawyers Association, the Jewish Lawyers Guild, New York County Lawyers. There are a lot of, criminal justice groups that will ask to be on these panels, as well as other various community groups throughout Manhattan. And under our rules, screening panels have to send out no less than 2 and no more than 3 candidates that they deem most qualified. That's what you mean when you say, I came out of a panel. This group, and depending on how many candidates are going to throw themselves in, there could be 15 to 20 people who make up the panel, will say that these 2 or 3 candidates are most qualified to come out and act as judges. And what do we look for when it comes to candidates? Well, one, there's a big packet that is sent out by the panel administrator to each candidate, seeking background information on them, their work history, where they've practiced, what do they practice, are they a sitting judge now, what cases have they worked on, how many trials have they done, in what courts have they worked in the city. They ask for references, who will vouch for you in the same way you do for a job interview. But they also ask for the contact information for your adversaries of some of your more recent trials that you've been on and you've taken part in. And they will call your adversaries, and we will see, because the references that a candidate gives to us, like any job interview, are going to be glowing, right? They should be. They're your references. But us on the screening panels, we will call your adversaries, and that, for us, speaks more loudly to your qualifications, to your temperament, than your friends do. How do you treat your enemies, right? That kind of goes a long way to how any of us really are as people and as professionals. We look at writing samples, copies of decisions that you have if you are a sitting civil court judge, or if you're a sitting housing court or family judge. If you're not a sitting judge, we will look at motions that you've written. If you don't know, a motion is something that you're asking the court to do, and you provide written argument first. And then there'll be oral argument later on, many times on motion, but it's often done on papers. And so we see how you write. We see what your legal thought process is. We see how you try to spin the argument and whether or not it's successful. Because a lot of what a judge is going to do is write decisions on the things that come before them, the issues that come before them. And so the screening panel will take all of this written information. They'll take all of this, information they glean from your references and your adversaries. And then oftentimes what the panels will do is break down into smaller subcommittees and interview each candidate one-on-one. So maybe 3 or 4 panel members will interview each candidate, one candidate each, to get to know them, really dig into this stuff. And then the subcommittees come back and they report their impressions and their findings to the whole committee. And then the whole panel will interview each candidate as a whole and try to get a feeling and a measure for them. And once all that is done, we then get together and we have a conversation. All right, who really wowed us? Who bombed it? Who is kind of in the middle? Do we have 3 people that we want to push out, or there are only 2 people that we're going to push out? What do we want to do here? And we try to find who is going to be most qualified. Now I will say that I think the process works. I think it's one that most groups, whether they're legal, bar associations or advocacy groups, don't come in with a preconceived political agenda. Others may disagree with that, but I think it's true, because quite frankly, I never came in with a preconceived political agenda, nor was I ever instructed to be. And I don't think I am, the exception to the rule. I think we all sit down and really try to figure out which of these candidates will make the best judge. For civil panels, it's a little bit different because they don't have to be a judge first. Sometimes they are. Sometimes they're a sitting housing court judge or a sitting family judge, and they're looking to get the civil proper. That's a whole different thing. Most of the time for Supreme, you are a sitting judge. You're a sitting civil court judge. You are elected to the lower courts. And you have a body of work that you can fall back on and show us. And I think that we on the panels look for 2 main things in a judge. And when someone gets pushed out of a panel as most qualified, I think any of us as delegates, because that's really the point here, right? What does it mean? And what are we looking for? And what is a panel really endorsing? I think they're endorsing 2 main things. The first thing they're endorsing is a certain legal acumen. These guys are really smart. These women are really smart. If you come out of a Supreme Court panel, you know what you're doing. You're a civil court judge who really took the reins in either housing court or family, landlord tenant, civil, acting Supreme. You wrote decisions and you make sense. Someone could look back and go, oh, all right, I see how that goes. And you weren't overturned by the appellate division. When you have a body of work that you put out there and it gets challenged by the attorneys and they go up to the appellate division, and the appellate division says, no, the court was right. That says something. And so we look to see, quite frankly, how much but the second thing that we look at, which I think is just as important, is the judge's temperament. And we hear a lot about that word. We heard a lot about it in the Kavanaugh hearings, frankly. And it's exactly what you think it means. How nice of a person is the judge, which quite frankly is important because the judge holds all the power in a courtroom. They can toss you out because they don't like the color of your tie. And you have to avoid someone who would actually do that. You have to have someone who will respect both sides, will respect the person who's a lawyer, will respect the person who's a pro se, will respect a position that they don't agree with, that they think is wrong, but is being put forth because that's the argument the lawyer's making in good faith. And it's, I would say that it's something that's rare in judges, less rare in Manhattan. I think that most judges in Manhattan have good temperaments. They don't lord over you in a way that they probably could. But you certainly look at it and you focus on that. That's why you call someone's adversary for civil. Or if they're a sitting court judge, sitting civil judge, you talk to colleagues and you try to get a measure of who they are, because you want someone who will treat everybody fairly. And that's really the buzzword. Can the judge be equal and fair to both sides in front of them? Because at the end of the day, in every court case, one person wins, one person loses. And you have to hope that the judge who's presiding over that is not picking the sides, that they're respecting what the law says and following what the law tells them they should do in order to see which side under the law should prevail and which one should not prevail. And if they're presiding over a jury trial, that they guide the jury so the jury is making a decision based on the law, not based on Googling the litigants and seeing what's posted on Facebook, which, trust me, happens and it's awful. So that's the panel process. And so when a judge at one of the parties or at a discussion led by FFDC or somebody else, and they say proudly, I've been pushed forward as most qualified by a panel, that's what we mean. That they're smart, they're even-keeled, and we think that they will run a courtroom the way it should be run in order to give both sides a fair shake. And to build on, just before I turn it back over to Kim, to build on something she said about the structure of courts, let me add something to that. The Supreme Court is the court of general jurisdiction in New York State. That means any case that's worth $25,000 or above is going to land in Supreme Court if it's a commercial or a tort matter. If it's a criminal felony, that's where it's going. It's going to Supreme Court. It's the broadest court that we have. It's the base level. Under that is a level we call civil. That's housing court, family, things that are less than 25,000. The small claims sort of cases, landlord-tenant, criminal matters like arraignments that are less than the felony level stuff. It's almost, if you want to talk about like baseball, and this is not to cast aspersion to these judges, but if the Supreme Court level is the major leagues, the civil court level is the minor leagues. That's where you get your start. And that's why most Supreme Court judges come from the civil court, because you cut your teeth on the smaller types of cases. You understand how the courtroom works and how to become a judge, because there is a learning curve. And once we, as delegates, think that judge is ready and seasoned enough between coming out of a panel and getting to know them, we then elevate them to the big leagues, right? And as Kim was alluding to before, because of vacancies and backlog, a lot of times the court system itself will take a civil court judge who's been there for a while. Civil court terms are 10 years. So they'll take someone who's got 5, 6, 7 years of civil court experience, elevate them to acting supreme to help plug those gaps, clear that backlog. And so we know that if a candidate is acting supreme, that at least one or two of their bosses in the court system said, all right, you're smart enough, you're good enough that you're going to help us out. You're going to come in kind of like when the rookie gets called up. You're going to help us out for a little bit. Because that's the other big difference between supreme and acting supreme and full supreme. In acting supreme, your boss can always, bring it back down to the lower level if they have to. Once you're elected as full supreme, you're there until you're voted out, generally speaking. So, Kim, back to you.
Kim, it's Frank.
Hi.
I'm sorry.
I was wondering.
I'm sorry I'm late, but my oral surgery went much longer than was planned. But I'm here if you have any questions.
Absolutely. I'm so sorry. I hope you're feeling well. I'm glad you were able to join us.
No, I'm in pain, but I have Tylenol in the medicine chest.
Sorry. So. Well, I am going to ask you a question in a moment, but because Matt specifically talked about some of the organizations, our next slide is actually a list from the 2020 Supreme Court panel, and they do always release the names of the panelists and the organizations they represent. And so I did want to share this with folks. I have to share my screen again. Give me 1 second here to do that. Okay, so as you can see, this is the list of organizations from the 2020 Supreme Court panel. These were all the organizations that were represented by a panelist, and those panelists, by the way, are chosen by the organizations themselves, not by the County Democratic Party. So the party reaches out to them and they send somebody. So they're, for folks who are on the phone or aren't watching, I mean, there are several organizations here. We have New York Women's Bar Association, the Asian Americans for Equality, a combination of bar associations, but also community organizations like the Fortune Society. We have the NAACP on here as well. So a pretty diverse group, and that's the idea, is to have a diverse enough group group that we, can hopefully create a very qualified and very diverse judiciary. Frank, I did actually want to bring you in. I know you have served on the county judiciary committee for many years, who puts together these panels. So I just wanted to get your perspective from serving on that committee, the organizations, who you reach out to, sort of your process in putting this panel together to screen candidates for Supreme Court.
Well, as Kim pointed out, the panel is made up of community groups and legal groups, and we reach out to them and ask them to send panelists. They don't always do so. I mean, serving on a panel takes time, but it's a good element to have in your resume. So I think we got a fair number this year. And the groups are the members of the county judiciary committee can suggest groups. So if anybody has a group that they want to be on next year's either civil court panel or Supreme Court panel, let me know and I'll suggest it.
So I'm going to move ahead. Want to chat about the political. At the end of the day, this is a political process, as we all know, because whenever there are elections, it's a political process. So look, technically anybody can run for judicial delegate. If you are a Democrat and you live in the 76th Assembly District, or no, actually, if you live in the county, anywhere in the county, you can run for judicial delegate in any of the districts. So legally, any Democrat who lives in the county can run. But the fact is you need to collect 500 valid signatures to get on the ballot, like running for anything else. And that is a really difficult thing to do, as we've all learned, those of us who've gone out and petitioned. And so what often happens is local Democratic clubs, like the Four Freedoms Democratic Club and other clubs in the county, they run slates of delegates and alternates, and they carry them on their club petitions with other candidates. And that makes it much easier, obviously, to get signatures. But what that means is nearly all of the delegates that we have do end up coming through local political clubs. It's not impossible for somebody to run as a delegate on their own. I've seen it done. It's just very unlikely. And candidates know this. Folks who are running for Supreme Court or civil court know that this is the process. And so they spend often years building relationships with these clubs, with club leaders, with party leaders, with the delegates. They attend club events and fundraisers. And if you've been to these events, you've met many judges there seeking to elevate to Supreme Court, because that's part of the process. They're trying to earn support of the delegates, and they do that by building these relationships. So that's where the process absolutely is very political. I think the benefit of a screening process is that the hope is, once we get to the political process, we at least know that everybody vying for the position is well qualified. And that's, I think, an important hurdle to get over. So I want to talk quickly about what happens at the convention. Many of you have been to a convention before, so you've seen this, but many of you have not. So I just want to explain a little bit about what happens at a convention. So the convention begins with a roll call of delegates. If a delegate is not there, their seat is given to the first alternate, and so on. The delegates then elect a temporary chair to run the meeting, and one by one, candidates are nominated via nomination speech. The candidate will then speak, and they either accept or decline the nomination. Many candidates know they just don't have the support of enough delegates to get through that year. And so they will give a speech, they will thank everybody, and they will very politely decline the nomination. A lot of folks who are new to the process, they see this play out, and it all, the word I've heard is like staged. It all feels very rehearsed. To some degree, it's a little bit rehearsed in the sense that, there is an agenda, there is an order of how the candidates speak. The county leader has an idea ahead of time who does and doesn't maybe have the votes. And so usually the first people nominated are people who've maybe just come out of panel for the first time or just haven't quite acquired the votes that they need to, to win the nomination that year. But ultimately, if a candidate thinks they have the votes, they're they may go for it. And so, but oftentimes a lot of them just know that they don't, and so they'll decline the nomination. That happens quite a bit. Floor fights, this is when two candidates for the nomination go up against each other for the same seat. They're somewhat rare, although it actually has happened in recent years, both in 2018 and 2019. We had floor fights for Supreme Court, where you had two candidates who felt like they thought they had the votes and they both went for the same vacant seat. And when that happens, there is a vote. The delegates are broken into delegations by assembly district, and the leader of the delegation then polls their delegates and announces the number of votes each candidate has, and those votes are counted, and ultimately whoever has the most votes wins. So, you know, we don't always know exactly how it's going to play out. I've seen these contested races happen in the last couple of years. It adds a little bit of excitement. But it does happen, and it has happened in recent years. And ultimately, the candidate who secures a majority of delegates wins the nomination, and that ultimately is the process. You know, there is a lot of politicking. Those of you here who are delegates and alternates have been invited probably to many receptions that some of these candidates are hosting this week. Because again, they want to be able to make their case. They want to be able to win support for that convention, and so that is the process.